Your hosts have earned a reputation as fierce and effective advocates inside and outside of the courtroom. Our partners are experienced trial attorneys who have been board certified in family law by the Texas Board of Legal Specialization.
Thanks for tuning into For Better, Worse, or Divorce podcast, where we provide you tips and insight on how to navigate divorce and child custody situations in the state of Texas. So I'm Jake Gilbreath, and today I'm joined by one of our partners in our Dallas office, Andrew Speer, to discuss preparing to testify in family law cases, which is always a more complicated topic than we think it's going to be, Andrew. And it's always interesting to see it. Some people are not prepared to testify by their lawyer. When we see that whenever we take over a case, or sometimes you experience that when cross-examining or taking a deposition at the other side, and it becomes quite obvious that they have not been prepared. So I guess let me ask kind of a broad, easy softball question, Andrew, but it is important. Why is it so important to be prepared either through deposition testimony, courtroom testimony, any type of testimony given under oath in a family law case?
Well, this isn't what most people think, but time is a critical aspect. If you don't know what to say or how to say it, you're going to waste a lot of your time and you're not going to be able to get all the facts out that you want. And then there's also, you could say the wrong thing, even if you don't mean to. You're always supposed to tell the truth, but if you start rambling in some random direction, if we haven't discussed, how does cross-examination work? How's direct examination? What are those, right? You could just have someone up there just chirping like a bird, right? Nonstop.
Yeah, not helping themselves, right? I mean, it's to your point. It's not, obviously the main goal anytime you're testifying is telling the truth. And then the goal after that is to tell a story, tell your story in court, and deposition's a little different. We'll talk about that. But yeah, like you said, Andrew, you could, if you're in court and you can't testify, you haven't been prepared, you're not going to get your story out, or you're going to look bad on cross-examination, or, deposition. And I see this a lot. If somebody's not prepared, they may very well be testifying honestly, but just being led by the lawyer on the other side into saying something that's not helpful for their case, maybe something they didn't mean to say. Maybe the lawyer put some words in their mouth, and that if they had just been prepared, then they could have seen those coming. Nobody's perfect, right? We do our best to prepare our clients. We do a lot of preparation for both deposition and courtroom testimony. Nobody's going to bat 10 out of 10, but there's a lot of tips you can do to kind of make it a better experience. So let's sort of break it down into between sort of depositions and the courtroom testimony, because two very different things. And this is going to be broad, right? We could talk for an hour on depositions. We could talk for 2 hours on courtroom hearings. But just generally speaking, could you talk to us and say kind of what's the deposition process? How can it be used in a family law proceeding? Then I'll follow up with that, asking you some of your tips on what to do and what not to do in your deposition.
Sure. So depositions are technically a discovery tool, like sending written questions you have to answer, but they're in person. So it's testimony as if you were in court in front of the judge. There's going to be a court reporter, you're under oath, you have to tell the truth, except there's no judge. And generally, it's going to be about 6 hours per witness. That can change, but that's the basic rule. I don't always like to use all my 6 hours at once. But if it's my client, I'm probably going to be preparing for a defense. I may want to depose them after, do a little cross-examination or something, but we'll probably go into that in a minute. But a deposition is I have a witness and I get to ask them questions, right? And what I'm trying to do is establish facts, and those facts will be generally needed for my claims. When were you married? Like if we're trying to figure out if there's a waste claim for a vacation to Vegas, when you go to Vegas, you can talk about documents. They can still object, but it can help, one, identify facts, and it can also help you find weaknesses in arguments and strengths.
Yeah, I think those are all good points. And I think additionally locks people in. It's surprising to our clients that I'm going to be asking a lot of questions of the other side about what's wrong with my case, right? Tell me all the horrible things you have to say about my case, my client, his or her positions. Because like you said, it's a discovery tool, right? And that can be surprising, right? Because you're soliciting all this quote unquote bad information about your side of it, and that's because it's a discovery tool in a deposition. And so that kind of goes to, if you're being deposed, Andrew, like what you were saying, is the rambling, and if you're being asked a question and they ask you a simple question and you just go off and you ramble and you talk and you talk and you talk, well, all you're doing is helping the other side and providing them information and probably creating a bunch of follow-up questions for them.
I always tell my clients, if you're talking for more than 10 seconds, you're hurting yourself. The longer the other side's letting you go and go and go, it's because what you're saying, they want to keep hearing and is helping them most likely. That's not always the case, but 95% of the time it might be true.
What other kind of tips do you have for clients, as far as, don't ramble, don't go off in the deep end. Nobody wins a deposition, is what I always sort of tell as a young associate. You get through it.
You were talking, one, it's a discovery tool, right? It's also an impeachment tool. An impeachment is your, are you lying now or were you lying then kind of scenario, right? I get you lock them into a position, like you said, right? And so they may lock my client into a position in a depo, and then at court, you're going to have to be consistent, because if you're not consistent, that's going to be brought up, and then you're going to be attacked with whatever you said if it's not the same. Now, you can work your way out of it. You're like, yes, I said this because X, Y, Z, and you can revise answers. But generally speaking, one of the purposes, or one of the more common uses of a transcript from a deposition is are you lying now or are you lying then, right? Now, what tips do I have? I always try, I'm thinking depo-wise. Well, you have to tell the truth, of course, right?
That's helpful, yeah.
Yeah. And, well, if you start lying, it'll always blow up in your face. I would say don't answer anything that's not asked.
How do you tell your clients, by the way, this is a side note, but I get asked this a lot. How do you tell your clients to dress for deposition, videoed or not videoed? I get that question more often than it's kind of surprises me how often I get that question from my clients.
Well, if they're videoed, I'd want them to be dressed how they'd want the jury to see them, assuming there's a chance there will be a jury or a judge. I would still want them to at least dress at least business casual if there's no video, because how you're dressed sometimes will also impact how you act. I know that's going to sound weird, but you don't want to roll in a t-shirt and basketball shorts. You want to show to yourself and everyone else you're taking it seriously.
Yeah, I think that's a good point. I mean, I think it does send a message to the other side, that this is serious. You're taking it seriously. You're prepared. Hopefully you've met with your lawyer for hours in preparation for your deposition. Hopefully you've walked through the process with your lawyer and gone through potential questions. You said tell the truth, and it is kind of a funny aside, but it's true, right? I mean, it is something I remind all my clients when preparing for the deposition. Even if it hurts your case, lying is, one, it's obviously illegal, but two, it's not going to help your case, right? It's going to blow, like you said, it's going to blow up in your face, and the other side's going to find out if it's true or not. If there's a bad fact in your case, everybody has bad facts in their case, right? There's not a perfect case out there. And lying about a bad fact or lying about anything is just going to make a bad thing way worse. I won't give too many details because it's, but there's, obviously I won't use names either, but I had a client once that it was during the height of the pandemic. We were on Zoom, and he had messaged somebody while being deposed, really kind of innocently. He wasn't supposed to. You're not supposed to message somebody when you're being deposed. And we had talked to him about it, but he just forgot. And it wasn't an inappropriate message or anything like that. It's just he shouldn't have been typing at somebody else while being deposed. And then the lawyer asked him, because we could all see him do it. Said, "Hey, did you send a message to somebody?" And he just, I guess, felt guilty that he'd been caught, and just immediately goes, "No, I didn't." It's like, okay, well, we all saw you do it, and then double down. Nope, I didn't do that. I didn't do that. And it's such a silly little thing. He should have just said, "Oh, sorry, shouldn't have done that. And instead, he kind of went down in flames over whether or not he had done this thing that didn't matter. And then, the problem with that is now you told a lie under oath. And what do we all know about people that lie under oath is that they're liars, right? Liars lie. And so it's just a problem, right? And so it's instinctive, right? Because you feel like maybe you got caught on something, or maybe you're embarrassed, and then even if it's something innocuous, you're going to lie about it, or tell a white lie, or tell a half truth. It's just own it is the best way of doing it. I say the same thing for clients. It all goes back to kind of your point, Andrew, about rambling. If you have a bad fact, right? Or let's say husband had an affair, you represent husband, you had an affair, and you're asking your deposition, did you have an affair? The answer is yes, with a period on it. It's like what you were saying about 10 seconds or more. It's yes. It's not, yes, so let me explain to you why it's not that bad. And it's really her fault, my wife's fault when you think about it, and this, and that, and really she did all these horrible. It's yes, with a period on it. So last sort of tip, we could talk for hours and hours about tips for depositions. And I know you do, Andrew, when you prep your clients, and I do the same. Those are some high level tips, but I'll say just kind of this last one, and this goes to all things testimony related. And it can be one of the harder things I tell my clients. But you can't be angry in your deposition. You can't be angry in your courtroom testimony. You can't be angry in your deposition. Anger never plays. And a lot of us have really good reason to be angry. Going through our divorce or our custody case, it just never plays well. And that's one of the hardest things to do. But if you're angry, you're going to end up saying something, that's going to hurt your case. You're going to say something that lacks insight. You're going to be the person that testifies that the other side doesn't love their child or has no redeeming qualities, all things that are bad to say. That's all driven by anger, right?
When they're up there and they can't say one positive thing about the other side, it's the good old trap, right? And they're just so mad they can't even dodge. And
that can really be devastating to her case, right? I tell people in depositions, and then again we'll get off it because we could talk about depositions for hours and hours. But I mean, I tell clients when preparing for depositions, it's really hard to quote unquote lose your deposition. You're not going to win it, right? This is the other side's opportunity to ask you questions. So it's not going to be good for us, right? Like there's no winning a deposition. We're going to get through it. But you really can't lose it because you're just there to provide testimony and tell facts, except for if you violate kind of the two rules that we've been talking about. Don't lie, do not lie, and don't be angry. If you follow those two guiding principles, really you're going to be okay. Obviously, we prep and we help you with more than just those two principles, but in all things testimony related and really in all things family law related and in life in general, actually, don't lie and don't be angry. Even if you have absolutely every single reason to be angry, which I get, but that does not play well in a custody case or a divorce. So a lot of this is going to carry over, Andrew, in courtroom testimony, but in preparing for courtroom testimony, what's that process look like for your clients, and what are some tips for that?
So what I do, I give them, have a little spiel about what happens. First of all, what's direct examination, what's cross-examination, what's hearsay, and how are we going to do this? So I go over hearsay. You don't want your testimony being what some other person not there said outside the courtroom, right? It's just going to waste your time and get blocked unless there's some exception. And if there is one, I'll tell you about it. Direct examination, I like to have it, I describe it as a staccato conversation of short bursts back and forth between me and them. And we're trying to do who, what, where, when, why questions and getting out one fact per exchange. We're telling the story, but every time I talk, you should know what the answer to my question is, right? And you should know why it's important. And so we're getting out what happened, why is it important? A series of that, and that'll tell a whole story, right? Because the facts together will lay out our case and what we want the judge to know. And that's it for direct. Or we're going to get documents and why is it important? It's always why is this important? It's not a series of facts is great, but you need to provide the context around those facts, or else we're just a bunch of robots, right? No, we're telling a story and why it's important. So each exchange, what is it? Why is it important? Right? Cross-examination, generally, your answer should be yes, no, I don't know, I don't remember. If they ask you what color is the sky, say blue, right? But you want to answer the question, but you don't want to ramble. Because again, the more you talk, when the other side is asking you questions, the worse it is, generally. I know if I'm asking someone questions and they're just telling me everything that's helpful to my case, I don't stop them, right? So who, what, where, when, why. I remember you and I had a case, and I think after that, we were discussing they only get 3 I don't remembers. You don't want everything to be I don't remember, because then, again, you're going to lose credibility with the judge, just like if you get caught lying. Just own it, and you can work with it. Because once you own it, you've got a data point, you can explain why, right? And if you lie, your why will not be heard.
Yeah, and it's funny because I do remember that I don't remember case. And, it's, if you don't remember, it is fair to testify I don't remember. But like you said, it's not supposed to be cutesy, and you need to answer the question. And this goes back to depositions with the same in courtroom. I always tell people, if they have a really devastating fact on you and your response is, I don't remember, then that's a yes, right? It's like, if the question is, did you ever call your wife the B word in front of the kids at the dinner table? And it's, well, I don't remember. That's a yes. So if it's something like that.
I'll do that sometimes when I'm asking them questions. I would love it if they are going to refuse to answer it, because I'm going to ask it 3 different ways. I'm going to ask what I know is a direct quote that you said, and you're going to say, I don't remember. And then the judge is going to think and know that you said exactly what I just said.
Right. And that Andrew's a more credible reporter of the facts than the person on the witness stand. That's true gold in cross-examination, when a judge or a jury knows that what I'm saying is correct and what the witness is saying is not correct. And if there's a difference between what I'm saying and the witness is saying, then I'm the one that's right. That's a great place to be in doing cross-examination. But it goes back to kind of preparing our clients, right? Like, you're not trying to be cutesy. You're not going to win cross-examination. Nobody wins cross-examination. You're going to answer the questions. That's why I'm going to add this in this war story, and back to the I don't remembers, just because I thought it was funny. I did have a client once, became an ex-client very quickly. There was a provision in the temporary orders that said if you're having a romantic or sexual relationship with somebody, don't have them around the kids while the divorce is pending. That's a pretty common injunction. And he had so-and-so, a certain lady, around the kids in violation of the court orders. And he was asked on cross-examination, we had so-and-so around the kids with her. So-and-so around the kids while the case is pending. Yes. And you have had a sexual relationship with her. I don't remember. Like, oh, that did not ring. That did not ring true. So it did not help things.
You get to ask, are you on any drugs right now that'll impair your memory? And you get to do that whole thing. The I don't remember, it's just, you're just setting up the other attorney to just take you down. Because, if I had that, I would be like, oh, are you okay?
So why would I listen to anything you have to say? If it's like, it's just other little, and again, you and I could talk about direct testimony probably for 2 or 3 hours, cross-examination for hours and hours and hours. Both how to respond to cross-examination, how to do cross-examination. I mean, I'm looking at a book right now at my desk, which is about 3 inches thick, about how to do cross-examination. So we won't do that. But today at least, other tips though, this, as far as preparing, I like what you said about kind of walking through with clients and kind of just how it's going to look, right? I mean, you and I are in court, every single week, usually multiple times a week. I know what that courtroom looks like. I know where the judge is going to sit. I know where the court reporter is going to be, but kind of walking through that before with a client can actually help with anxiety, in my experience.
Sometimes I've gone back and forth on this. I'll do my own little outlines, but the second you get in court, it goes sideways, right? So it'll just be bullet points at best. I'll sometimes try to work on that with the client, but I don't know. In my experience, you're not just going to be sitting there reading questions off a piece of paper. It's going to be a conversation, and you can create a plan, but I don't know. They want me to like send them questions and ask ahead of time. Maybe, but once you get in there, you never know what's going to actually happen, right?
Yeah, I get that question a lot. People ask me, can you send me the questions you're going to ask me? And a couple of issues with that personally. I'm kind of like you. It's like, well, I'm going to have an outline. I'm going to have bullet points, but direct examination can just maybe we go down one path, or I can tell, a particular topic is not playing that well. And so it's going to be fluid. The other problem with actually giving somebody the direct examination questions, actually giving your client, here's what you're going to be asked, they end up memorizing their answer, then they sound like a third grader giving a presentation on the Constitution. Right. It's just completely memorized. And every single question is a speech, and rehearsed. And that's not persuasive. Other kind of broad tips. Again, we could write a book, probably 3 inches as well. We could write a book on cross and direct, but other just little pet peeves is like, same as deposition, dress professionally, right? I've had lots of stories over the years where you forget to tell people to dress professionally, or you do, and maybe you don't specify what we mean by professional. I have had somebody roll up in court in basketball shorts. They were promptly told to go home and change. And then the other one is, this one's silly, but show up on time. And on time in courtroom means at least 30 minutes early. It is shocking to me when it never happens with my clients, but I see people roll up 1 minute early. 1 minute, that's not early. 1 minute before the start time. I see people roll up after the start time, and we're talking about your kids or your divorce, and you're not showing up on time. That's a great way to really start a hearing off bad if you're late. Obviously for the lawyers, but clients too. And if we're waiting around for you because you're parking or you're stuck in the elevator or whatever, that's telling me as a judge that maybe you don't take this as seriously, or you take it seriously and you're not a functioning enough adult to be here on time. So be on time.
My goal, I tell clients they've got to be there half an hour early, right? And then I try to be there before that. And, depending on, sometimes I always try to give myself an hour, because you never know what traffic's going to be like. I guess it depends on where your case is too. But yeah, at least half an hour. And if they can't be there on time, the judge will read into it. Or at least I think they're reading into it, because I would, right?
I would absolutely would. Well, like I said, that's said several times now. We could go on, and if I would take anything from it, it's you got to be prepared, right? I've seen it where we take over cases and somebody wasn't prepared for court. They're told the day before, maybe a little bit of an outline, or their lawyer meets them for the first time at the courthouse. It's just, it's not, you're not going to have a good product that way. Courtroom, and Andrew, I think you'd agree with this as a litigator. The courtroom work, the actual work in a courtroom, is probably only about 20% of it, right? 80% of it's preparation.
You've got to have your exhibits ready. Your client has to know what they are, right? If I show you something, you have to be able to explain what it is and why it's important. What is my goal, right? I can't just show up. Everyone knows when you're just asking questions to ask questions, right?
Yeah, it's not completely rehearsed. And obviously it's unpredictable because stuff happens in the courtroom, but it should be planned, I think is the best way to describe it. So yeah, like I said, we could talk more and more about it, but that's a very broad overview. But for all of our clients, of course, in preparing for depositions and courtroom testimony, there's a much, more extensive process for that. For those that aren't being represented by our law firm, make sure you're meeting with your lawyer, preparing, getting what you need. So you're showing up, feeling comfortable going to court. And like we talked about, where you actually, it's been explained to you kind of what our goals are and how to accomplish those goals. So let's wrap up with that for today. That's what we have. So Andrew, thanks for joining us. For all our listeners, if there's a topic you want us to discuss on the podcast, or if you're interested in speaking with one of our lawyers directly, including Andrew, please email us at podcast@waltersgilbreath.com. I'm Jake Gilbreath. Again, I'm here with Andrew Speer, and thank you all for listening.
For information about the topics covered in today's episode and more, you can visit our website at waltersgilbreath.com. Thanks for tuning in to today's episode of For Better, Worse, or Divorce, where we post new episodes every first and third Wednesday. Do you have a topic you want discussed or a question for our hosts? Email us at podcast@waltersgilbreath.com. Thanks for listening. Until next time.